Hello, and greetings to distinguished colleagues listening to this address. I'm Helen Dodds, and I'm a member of the Legal UK Taskforce on Commercial Dispute Resolution and the former Global Head of Legal Dispute Resolution at Standard Chartered Bank. I'd like to thank the organisers of the St Petersburg International Legal Forum and the Law Society of England and Wales for inviting me to speak to you today. I'm going to discuss the guidelines for the resolution of disputes following the 2020 pandemic, now known as the Bickel Guidelines. These were published by the British Institute of International and Comparative Law as part of its Breathing Space initiative in September 2020 and reissued in May 2021, translated into 6 languages: Mandarin, Arabic, Spanish, German, French and Japanese, and we hope to have a Russian translation soon. I had the great pleasure of co-authoring the guidelines together with Guy Pendell of CMS Cameron McKenna Oswang LLP and Adam Johnson QC, now Mr. Justice Johnson. If you'd like to take a look at the guidelines, you can find them on the Bickel website under Projects. By way of setting out the history of the guidelines, in April 2020, in response to the growing pandemic, Bickel published the original Breathing Space Note, authored by a number of eminent judges, academics and corporate lawyers. This was a high-level concept note that discussed the potential impact of COVID-19 on businesses and their supply chains. It expressed concerns about the prospect of a deluge of litigation and arbitration, placing a strain on the system of international dispute resolution and reducing the prospect of more constructive solutions. It called for the adoption of a more creative and graded approach and the encouragement of a legal environment which is conducive to optimism and a global recovery. This was followed in May 2020 by a second note, since updated, authored by William Blair QC, Dr. Eva Line and others. This was a more detailed exposition and exploration of potential private law responses, relevant dispute resolution processes and mechanisms, referencing steps taken by governments to that point, the various legal theories that might be implicated in any such disputes, and the kinds of remedies that might be sought. At that point, I and my co-authors took up the baton. Since the beginning of the COVID-19 crisis, a number of governments have taken steps to modify the actions that may be taken to enforce contractual rights. However, not all governments have taken an interventionist approach, and where they have, most of the measures deployed are, in our views, quite rightly, expressly stated to be temporary in their application. As time passes, we may expect their impact to cease, while the time period for bringing COVID-19 related cases and the progress of the hoped-for economic recovery will continue for several years. With this in mind, and prompted by the publication of the first 2 notes, we, the authors, thought that it might be helpful to create some pragmatic guidelines that could be followed by business in the event that COVID-19 impact gave rise to legal disputes. They were to be framed both in terms of potentially avoiding traditional formal dispute resolution processes and using alternative dispute resolution methods, and also in terms of conducting legal disputes in the least damaging way if these proved unavoidable. Following the themes of the first 2 notes, they would propose practical steps to inform how to manage legal disputes in the light of COVID-19, in a way causing the least collateral damage to the commercial environment and the least burden to the systems, court and arbitration that might ultimately adjudicate on these disputes. In that sense, the guidelines are part of a natural progression from the high-level thought piece to the legal examination to the practical application. So what do the guidelines say? The guidelines set out how business and legal communities can respond to the pandemic in a way that assists economic recovery, and we'd like them to become a point of reference for both business and legal sectors. They are practical. Our aim is to create something simple, clear and flexible that can be used by businesses throughout the world, in any jurisdiction, and which are compatible with any legal dispute resolution system, and aligned with the range of international government initiatives I have already mentioned. They are not intended to be a code of conduct that must be signed up to. Rather, they can be adapted at will by one or all parties, and where relevant, their litigation funders, on a case-by-case or more general basis. They're intended to enable the parties to think beyond formal litigation system parameters, rather than being constrained by these. They should not be weaponised or used to disadvantage other parties. We expect them to be of most relevance in the world of commerce, and so we've focused on contractual relationships, but they could apply to a wider range of disputes. For example, they may be useful in common law jurisdictions in cases involving economic torts, such as procuring breach of contract and fraud, and issues such as mis-selling and misrepresentation. They were framed in response to the COVID-19 pandemic, but could be used routinely in future in any type of commercial dispute. Our aim is to avoid or minimise protracted litigation or arbitration by encouraging parties, where they do have more traditional legal disputes, to manage them in speedier and more focused ways. They encourage management of legal disputes in a manner consistent with ESG principles, focusing on the G in ESG and asking companies to think about how dispute management fits into good governance. They're clear that they preserve parties' legal rights. There's no compulsory element. The spirit of the guidelines is about making constructive choices. We hope that they can provide a roadmap for those less familiar in managing disputes, helping them to understand the options open to them to resolve their problems and realise that they are not inevitably headed down the road to court. For example, smaller businesses may find that they have legal disputes with other parties with whom they may have had previously good business relations and may be looking for guidance on how to address these disputes while still preserving those good relations. We believe that they are complementary to existing corporate procedures or regulatory requirements and expectations. Businesses that are accustomed to legal disputes can use them alongside their own internal dispute management processes. Many large corporates, conscious of ESG and reputation, will already have these processes, focusing on efficient and appropriate dispute management. The guidelines are designed to complement and not replace these. And the guidelines have been peer-reviewed by legal and business stakeholders. Before we published them, we took feedback from in-house counsel in a number of sectors, including financial services, oil and gas, engineering, food and drink, and communications. We also discussed them with legal consultants. We know that the most commercial organisations are very pragmatic and want to spend their time building their businesses, not in pursuing legal disputes. They fully understand that disputes cost money, swallow valuable management time that would be better spent on making the business successful, and damage commercial relationships. Readers studying the guidelines may think that they state the obvious and that businesses don't need to be told what is basically common sense and good behaviour. But sometimes it's useful to be reminded of what the options are, and it can be helpful to bring a connected set of ideas and themes together in one place. We hope that the guidelines deliver that and that you'll take a look at them. Thank you for listening.